Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly, every other Thursday, community conference call. Today is November 16th, 2017. I have a bunch of questions which I consider to be frequently asked questions. As usual, I will deal with those questions first, give it my best shot, let you folks know what I think. As you heard when you logged in, this is not intended to be a comprehensive consultation. I do the best I can in the time and with the information that I've got, and this does not create an attorney-client relationship. Okay, that said, let's begin with the frequently asked questions first, and I will ask you as I go over the questions if you have a follow-up questions. Then we'll deal with the other posted questions, and finally, time permitting, we'll deal with new questions. My first frequently asked question is relatively easy to answer. Is an interview required for compelling circumstances EAD? And the answer is no, not so far. Government has not indicated that they'll be requiring an interview before issuing a compelling circumstances EAD. That's only confined to the I-485 applications. Any follow-up questions on this? Jay Vijay has posted this. Any follow-up questions, press *5. If you press *5, okay, let's go to, I have two follow-up questions.
Sir,
Oklahoma. Yeah, you must be out.
Sir, I have a follow-up question on this.
Yes, sir. Go ahead.
Yes, sir. So the question that I wanted to ask is, until what period can I get the compelling circumstances EAD? So is it until the time my priority date is current?
The compelling circumstances EAD will continue to be extended based upon your application and continuing need. I'll give you an example. We have a compelling circumstances EAD for somebody who's undergoing medical treatment, and because their disease is so unpredictable, it's difficult for them to hold on a 9-to-5 job. So they need flexibility in both times as well as the kind of job they can do. So I-140 is approved, priority date is not current. They get their compelling circumstances EAD. We'll keep renewing that as long as the compelling circumstances exist until the priority date becomes current. Okay. Now, I don't remember the entire regulation off the top of my head, but typically that's the way it's supposed to go, from what I recall. Does that answer your question, sir?
Yeah, that answers my question, sir. But again, another question is, I have two priority dates, one in 2008 and one in 2014. So which one will be, considered?
You have only one priority date, the earliest available priority date. So you probably have a 2008 priority date.
Okay. So I have to prove that my 2008, because I don't have an I-140 document, but I put a FOIA request to get I-140 application.
The way this works is that because the priority date is the property, so to speak, of the individual, government actually runs periodic sweep, which you would call a SQL query on the databases to make sure that they are automatically assigning to you the earliest priority date to which you are eligible. Okay. So even if you don't have any evidence, they should still give it to you.
Oh, okay.
So yeah, it's a good idea to get the FOIA in there and see if you can get copies of your documents.
Yeah, I got the copy of the document, sir, but it's not an I-140 approval document, but it says that, I-140 application, and then in that they have the approved stamp, and then they put the priority date in that.
Good.
But when I used to track that, and then they have a SRC number, right? So
Okay.
when I used to track that in the website, I don't get any status.
Don't worry about that. If the I-140 was approved, you should be eligible to receive that priority date and keep it. Okay?
Okay, thank you, sir.
You're welcome. All right, let's go on to Arizona. Go ahead, please, Arizona. You have a follow-up question?
I'm not very sure how that's related to me.
No.
I have a very different question.
No, I can't.
Yeah, okay.
I'm not doing new questions right
Oh,
now.
sorry.
So let me finish
Okay, that's fine
all
then.
the questions. Then we have
Okay,
time. I'll go over your question. Okay?
sure. Okay, lovely.
Very good. Let's go on to the next frequently asked question, which is about, this is from VPS 2122. Can we open a company while on EAD? Well, first of all, almost any EAD, whether it is OPT or H-4 EAD or L-2 EAD or 485 EAD, allows you to open your company. And when you open a company, you are allowed to do what any business owner can do. As long as you have your EAD, you can hire people, you can expand your business, you can do anything that a business owner normally does. Now, specifically addressing this issue, I filed I-140 under EB1. I'm on L1A, so it's an EB1C based I-140, international managers or executives. Spouse is on L-2 EAD. Can I open a company on my spouse's name? No. You cannot open a company in your spouse's name. That would be illegal if you do business through your spouse. But if your spouse wants to do business, he or she can. So there's a shade of distinction between what you said. Can I do business through my spouse? No. Can my spouse do business? Yes. So no, you cannot do indirectly what you cannot do directly. When I file my I-485, do I have to provide any documents, W-2 tax returns related to my spouse's company? She probably will have to. From what I recall, the I-485 would ask her, but it has nothing to do with you, unless you're filing joint tax returns, in which case, yes, you will need to provide copies of all your documents. And it is not necessary that she get a W-2. If she's getting a distribution instead of a salary, that's fine. Now the next question you have is, when I go for in-person interview for the I-485, what kind of questions can I anticipate if I open a new company? Well, first of all, I don't think, if the company is not yours, your wife's, and you have nothing to do with it, then you have no questions about it. Your wife will have to answer questions about what kind of company, etc. If they want to know, they may not want to know. So far, what we've been hearing is that these interviews are not very detail oriented. They are going over the I-485, making sure whatever you've filled on the I-485 is correct. As far as what kind of interviews people who have done employment-based cases can expect, you should look at the last couple of community conference calls that I've done, in which I've discussed this in a greater detail, that they can look at your past, any status problems, anything like that in your past. They can look at your present. What are you doing right now? Are you in status? And they can look at your future. What is your intention? Where do you want to go work? So past, present, and future can be examined. So far, it has not been. *5, please, on your phone if you have a follow-up question. Press *5 if you have a follow-up question. Okay. So we have one follow-up question from Pennsylvania. Pennsylvania, go ahead, please.
Hi, Rajiv. Good afternoon.
Good afternoon, sir.
For example, my wife has like EAD and I am on H1. So can she employ me in her company? Is that legal, or do I need to amend my H1 in that case?
These are two different questions. First question is, can I be hired by my wife's company while I'm on H-1B? Yes, you can be. Now, do I need an H-1B amendment or transfer? Yes, it's just like going from one company to another. But bear in mind, if you have a family-based company, then you may not be able to do a perm through her. That becomes a lot more complicated. But H-1B is theoretically possible. Again, I don't say practically because I don't really know your case. But if you have a genuine case and the company is doing genuine business, I don't see any reason why you cannot be hired by a company owned by your wife. Any questions?
Also, same time, can I work for other company like multiple H1s?
Yes. I always give this example. My favorite example is we had a client a few years ago who was holding on H-1B 3 full-time jobs concurrently. So you might want to think, hey, how can that happen? How can one person be working 120 hours each week? And the answer is he could because he was a system administrator. So he only got called when there was a problem. As long as the systems were running okay, he never got called. Moral of the story is you can have concurrent H1s. You have to file for it, of course, but you're allowed to have 1, 2, 3, 4, 5 H1s going on at the same time with different companies. Okay.
And all the companies has to be like similar job, or
No.
say like my wife is some internet company job.
As long as you qualify for it. Let me give you an example. Let us say you're a Java developer, but you also know Oracle databases. So you could hold a job as a database developer, as a database administrator, as well as a Java developer. Why not? You qualify for all three of them.
But if for example my wife opened some different company not related to IT, so in that case, can I still do H1 for my wife's company?
No, because the H1B requires that the job must require a specific degree and you must have that degree. So if the job, for example, if she starts doing import-export and she's exporting or importing leather goods, that has nothing to do with technology, which is your degree. If on the other hand, she was importing, exporting, I don't know, computer parts and you have a degree in electrical engineering, maybe that would qualify. So your degree must be relevant to the work that you will do.
Okay, I got it. Thank you very much.
Oh, you're welcome. Alrighty, let's go on to the next frequently asked question. Well, this is also an interesting question, and I've dealt with it many times. Does H-1B extension denial invalidate an existing H-1B? So Mukherjee 19 says, H-1B is good till August 2018. If my case is denied, can I continue till August 2018 anyway? And the answer is yes. Yes. The previously approved extension doesn't go away. The only way that can go away is if government separately issues a notice of intent to revoke, gives you notice and a chance to respond, and then denies. So getting back to our original question, does H-1B extension denial invalidate an existing H-1B? It does not. Okay. *5 if you have a follow-up question. *5. Okay. Let's go on to the next one. Oh, there is a follow-up question. Let us see.
Hi, Rajiv.
1 second. Let me see. You are from Illinois. Go ahead, please. I can hear you.
Yeah. So I wanted to ask, let's say like, for example, my H-1B expires on Feb 24th, 2018.
Right.
What's like the minimum period before the expiration date I can go out of the country and come back?
Theoretically, you can go one day before, you can go and come back a day before your H-1B expiration. The reason I say theoretically, because in Trump's America, Customs and Border Protection is not very predictable. They were not predictable to begin with. Then having a White House that seems to make things even more chaotic has not helped matters any. Therefore, when you come back, they could theoretically say, hey, are you going to just go in for one day? Why are you going to go in for one day? As far as the law is concerned, you are allowed to come back even if you have 1 day of H-1B left. So the short answer is, Minimum how much time there should be between the time you enter and the status expires? 1 day is okay. As a practical matter, it helps if you have longer duration. Sure. Okay.
Right. Thanks.
Oh, you're welcome. Okay. So then we are done with this one. Then we have another question. And this one is from California. California, go ahead, please.
Hello, Rajiv. How are you?
I'm good, sir. How are you?
I'm doing good, thank you. I have a related question to this. I have a H-1B extension with my current employer, which is expiring in 2019. That is in the month of April.
Okay.
But my visa stamp, which is on the passport, is expiring on February 2018.
Okay.
Okay. And I'm planning to visit India in say January. I don't want to go for the visa interview. So can I come back and while entering US, can I show the latest I-797?
Okay, let me understand this. Give me the dates again. Visa expires in 2018. H-1B expires in 2019, correct?
Yes, the extension that I got, which is my current employer, is expiring in 2009.
Now,
the stamp visa is of the previous employer.
You cannot enter USA after the visa expires. But before the visa expires, what I would recommend is keep both original H-1B approval as well as the extension approval at hand. Remember this. This is important. Show them only the extension first. Okay? Because CBP tends to make this mistake a lot. If you show them the old approval first, they will give you an I-94 which is good only till 2018. Okay? So show them the extension approval first. They should give you an I-94. You're entitled to an I-94 all the way to 2019. Don't accept 2018 I-94. Okay? So
I should not hand my passport to the CBP officer, basically.
No, you'll have to hand over your passport, but the I-94 should not be coextensive with the old approval or the old visa. It should be coextensive to 2019, your new approval.
Okay, so I should hand the passport and then along with it the new I-797.
Absolutely. That's what you should do, sir. Okay,
even if the visa stamp is from a previous employee, it doesn't matter.
It doesn't matter. We've had this discussion with the consulate. They've told me, oh, you've got to get a new visa stamp if you change employers. I showed them their own standard operating procedures. I said, no, this is what your standard operating procedure says. I don't need a new visa. They never got back to me. So my suggestion would be, I don't see any reason why you should be getting a new visa.
Okay, it doesn't matter how long, if I travel in January also, it should be fine, right?
I think so, yes, sir. As long as the visa is valid, why not?
Okay, the CBP officer wouldn't ask why didn't you go for the visa interview kind of a thing?
Even if they do, the answer is it is not required by law. Why would I want to? Who wants pain? Why would I want to go? If it is not required, why should I do it? Okay. Good luck.
Thank you so much for your answers.
Bye-bye.
Thank you.
Okay, I think we have one more follow-up question. Let's get to that. And this one is from Oklahoma. Oklahoma, go ahead, please.
Rajiv ji, a follow-up question here. So you mentioned about entries and exits. So my H-1B amendment is valid until April end of April 2018. At this point of time, can I maybe next week or so, can I go out of US and then come back without any problems? Is there a minimum period, before 6 months I should, travel, or is there you mentioned 1 day, right? So
as I answered before, now you asked me a loaded question. If we are in court, I would object to this question as being multiple question because it has two sub-questions which are being asked together. So for example, if I ask a witness, are you good looking and stupid? That's a double question. What do you say yes to? So what you asked me was, can I travel without a problem? So you can travel. Problem, I don't know. Okay. As far as the law is
Okay, no,
concerned,
what I meant, what I meant was the, CBP, during the entry to US,
right.
will they?
Right. And the thing is, legally, you're entitled to travel as long as you have a visa. But as to whether or not you're going to have problems depends upon the CBP officer. If your papers are all straight, you're working where you're supposed to be working, getting paid routinely, regularly, I don't see any issue. I don't see any reason for you to worry about trouble. But I always tell people, before you travel, it's a good idea to check with your lawyers to make sure there's no bump in the road of your H-1B. Is there any place where you need to worry? For example, you had changed locations, an amendment was not filed, something like that. As long as the papers are in order, go for it, travel.
Okay, thank you, sir.
Oh, you're welcome. Alrighty, then I think we are done with this round of questions. Let's go on to the next frequently asked question. Okay. Here's another one. What can be done if an H-1B is denied while in the United States? Can new H-1 transfer with new employer be initiated? Can one apply for visitor visa? See, this question again is an incomplete question. You can always file another H-1. You can file an H-1 renewal. You can file for an H-1 transfer. You can file for an H-1B amendment, even if the H-1B is denied. While in the USA, depends upon whether or not you have status. Let me give you an example. You're authorized to work in Santa Clara, California. You are working there, and you have 6 more months left on your H-1B approval. In the 5th month, you file an H-1B, premium processing. It's an amendment. It is denied. You still have 4 months, let's say, left. In those 4 months, you can do whatever you want because you still have time left. If you're maintaining status, you can file for an extension and another amendment because one denial doesn't foreclose another application under the same category. So if I'm denied an H-1B amendment, as long as my status is valid within USA, I can always turn around and file another application. So if your original status is still valid and maintained, you can do everything. You can do a transfer, an amendment, an extension all over again. But what if you are not in status? Chances are you will have to go outside USA for visa stamping before you can start working with a new approval. But a new application can always be filed. Applying for a B1 visitor visa or a tourist visa or a business visa also follows the same rules. If you still have status, you can do so within the United States. Otherwise, you have to go outside USA to do it. *5 if you have a follow-up question. *5. Okay. So we have, let's see. So far, it looks like we have one question on this, which is from Minnesota. Minnesota, go ahead, please.
Yes, sir. Thank you. Thank you, sir. So my question is that, did a H-1 transfer because premium processing was not on, so did a regular H-1 transfer.
Sure.
Started working on receipt.
Okay.
Okay. Got H-1 approval on the transfer.
Okay.
After a month, they send a RFE.
Okay.
Now trying to reply, we already replied, my lawyers has already replied for a RFE.
Okay.
So within this time, my previous employer has revoked or, he provided a,
sure,
he initiated a revoked on my existing H-1B.
I understand. Okay.
Now difficult part, what I'm thinking through is that, if, my lawyer has filed a strong reply because they had already approved my H-1 and, again, they sent RFE. But in worst case scenario...
Hang on 1 second. What they did was send you a notice of intent to revoke, not an RFE, right?
No.
You said...
I did a...
Did they already approve the H-1?
My previous employer.
Oh, the previous, okay.
Yes,
all right. Keep going. Got it.
Yeah. So my transfer was approved. They
Right.
send a RFE. We send a reply back to them. It is in progress.
Okay.
Meantime, my previous employer has initiated a revoke on my existing
Right.
H1,
Right.
which was valid for 2020.
Right.
Okay. So my question is that, I got a H1 transfer approved, then RFE, we filed a reply. In worst case scenario, if that doesn't go through, what are the options one can have?
Well, one obvious option is to apply for another H1 premium processing and hope that you get approval within the United States, because you can claim the 60-day grace period. But if it doesn't happen in the United States because you filed premium processing, you should be able to get an answer very quickly. Worst case scenario, you go outside, get a visa stamping done.
In case of same employer will file a new I-29, right? Like transfer.
Any employer can file it, doesn't have to be the same employer. Okay. Now, one thing I would like your lawyers to check, that 60-day grace period is always, it works like this. It is the longer of either your I-94 duration or the 60 days grace period. So let's say your I-94 is expiring in 45 days and you got laid off or your employer's employment ceased today, then the grace period is 45 days, not 60, because your I-94 is expiring in 45 days. So when somebody's H1 is revoked, what rule applies? I don't remember off the top of my head. It's a new regulation, but that's something they should check. Otherwise, you have that 60-day grace period. In any case, if you don't have the 60-day grace period, you've got premium processing, make your case to the government to give you status within the USA. Worst case scenario, you go outside, get a visa stamping. Okay.
Thank you, sir. One more question, sir, on I-94.
Right.
So in this case, because H1 transfer has been denied, I don't hope so, but in this case, my I-94, the existing I-94, which was my previous employer, has been, they have initiated the revocation on that, right? And again, my H1 transfer has been approved, right? So which I-94 somebody can
that
consider?
is one of those issues that has not been covered by any regulation. So the practical answer is still do your H1 premium processing, whatever you're planning to do with it. Make your case to the government, tell them that we've got the grace period. Tell them I've got two I-94s, both of them were valid. Let's see how it works out. Now, I think there's a little bit of confusion in your narrative. The confusion is this. You filed for a transfer. As soon as the receipt came, you started working with the new company, correct?
Mm-hmm. Yes.
Then the transfer was approved, correct?
That's correct.
Once the transfer was approved, then they later on said, oh, no, we are sending you another notice. They sent you a notice, right?
They sent an RFE notice.
That's not an RFE. When a case is approved, technically, they send a notice of intent to revoke. It's an NOIR.
No, they sent the special occupation RFE.
That's very odd, because normally once they've approved the case, they shouldn't be sending an RFE. There is no provision in law for that. They have to send a notice of intent to revoke. Okay. But anyhow, it doesn't really matter. Your next step is clear.
In the previous...
Your next step is clear. File your premium processing H1, see how it works out. Okay.
Yeah, so in the previous session, I asked the same question that, it can be valid scenario, and you said, you suggested that, that is not possible and they should not do that. But there is no, technical, I don't know if there is a technical rule or anything we can take up on that. That you already approved H1B transfer.
Look,
now
they can simply switch the RFE with the notice of intent to revoke. It's the same issue, but it's definitely a procedural problem. Government shouldn't be doing it like this.
Can we take a case? I'm not saying, but can we take a points on this in favor of us?
Let's talk about theoretical and practical. Theoretically, this is wrong. As a practical matter, they can just turn around and send you a notice of intent to revoke. You're in the same place as today, or you're in the same place tomorrow when they send you the NOIR as you are today. So it doesn't really matter. Why spend money on something like that? Okay, it doesn't
Right,
give
but
you
I mean,
any
yeah.
substantive advantage. You've proven a point, but proving a point costs you a couple of $1,000s. What is the use of that?
No, correct, understand. Yeah, my interest is, just wanted to, be in the status and work, like, that is the only
Yeah, but that's not
point
going to
if we
last
can
for
help
long.
anyway.
That's not going to last for long. Maximum you'll gain a couple of weeks with that, maybe 4 or 5 weeks, 6 weeks. Personally, I don't see any use in it, but you can certainly explore it with your lawyers if you want.
Sure, sir. So, I mean, my lawyers have filed a reply to that. But I mean, as I said, that it was a RFE for preferred position. So I think
Okay.
we'll check it out. Sir. Yeah, thank you very
Well,
much. And sir,
yeah.
the last question on visitor visa. Can we do visitor visa as a last option?
Everything depends upon whether or not you are in status on the date you file for the relief. Okay.
Okay.
I don't think you'll be able to, not within the United States.
Sure, sir. So we can file, I mean, I can file a visitor visa now also, right? Because I'm in status.
Well, if the case is not revoked, again, I'm assuming it's the notice of intent to revoke. Once the case is approved, you are in status, certainly worth trying, but it will require a little bit more discussion than we have time for. What I recommend is visit this issue with your lawyers. If they understand your situation, they have all the paperwork, they can better advise you. Technically, if a case is approved, you are in status. Until it is revoked, you are still in status. So until they take final action on revocation of some kind, you are okay. You could file for a B1. But again, because I don't know the exact facts of your case, I'm going by what you are saying or what you know. Your lawyers might have a better idea than I do. Okay?
Sure, thank you. I mean, just last clarification. They haven't sent any revocation. They just send a pure special occasion
I understand.
RFE.
I understand.
Just to,
I understand
sure.
what you're saying, but that is definitely a non-routine procedure. That doesn't make any sense. Okay.
Yeah, got it. Thank you very much.
Good luck. Yeah, USCIS does weird things. They always did them, but now even more so. All right. Now this is a question that came to me as an email, and I told this gentleman to go ahead and send it to Monica so she can post it. Normally we don't reopen once we close the thread, but I think this is an important question. And I could have answered it yes or no a couple of weeks ago, but things have changed. What is the problem? Well, I want to take a long break on H-1B. Let's say I'm an Indian citizen on H-1B visa. I'm an engineer. My green card is being processed and my I-140. Well, I guess it's being processed. Being in EB2 category, I'm assuming it is going to take anywhere between 5 and 8 years before I get my green card. Probably. I'm planning to taking a work break for about 6 months to a year and do a few things that I've wanted to, but I've been pushing indefinitely, like volunteering with a non-profit, spending time with my family, exploring options to start my own startup. So there are two scenarios. My company gives me a sabbatical leave. First of all, a leave that long would not maintain your H1 status. We had a case in which somebody was able to get change of status within the United States after being out of work for almost 2 years, but she had a really, really good medical reason, or really bad medical reason, I should say. So for something like this, I don't think you can maintain status. Maybe a few weeks could be okay, 3, 4, 5 weeks, but if you want to do it for months upon months, having a sabbatical will not maintain your H1 status, in my view. If I have to quit, what do I do to come back after my break? Okay, now going back to what I was telling you, what has changed in the last few weeks, and I think they are wrong, and we indicated to them very strongly. Let me tell you what the situation was, and you can see how it is relevant to your case. So we have this corporate client who have a very successful business in software, and they hired somebody here in the United States, an Indian professional who was working for the company. They have a few hundred people working here. And this gentleman came and said, look, I need some personal time off. I've got to go to India. And they have some problem in the family. So with their consent and blessing, because they're a large company, they could deal with the absence. He took time off. He went to India. In the meantime, there was a visit from USCIS. They came for a site visit and they said, where is this guy? And of course, we responded saying that he's not here. He had to go. And here's a letter from him asking for leave. And he might be gone 6, 8, 9 months, maybe over a year. Government sent us a notice of intent to revoke, to which I responded saying, you're wrong. This is a genuine case. It's not like the guy is sitting at home not working, or we don't have a project for him. We have a lot of work. And in fact, he's indirectly working for us through a vendor. He's doing some work for us. But the bottom line is this. Now, it seems like every time there's a gap, long gap in the H1, government might want to revoke that H1. At least they'll try. I think it's illegal. So, in your situation, your question was, how do I get back onto H1? Over the next 6 years, you can at any time file for another H1 without any quota issue and come right back to USA on that H1 after getting a visa stamp. So, I don't see any problem getting back onto H1. If you want to remain in the USA, you have a problem. But if you want to go outside USA, no issue. Worst case scenario, they can revoke your H1. You can just reapply. *5 if you have a follow-up question on this. *5 on your phone if you have a follow-up question. Okay. This is from California. California, go ahead, please.
Hello, Mr. Rajiv. This is Sunny. I had initially posted that question.
Yes.
And
I think you had contacted me on LinkedIn. You're one of my connections, right?
That's right.
Oh, okay. Yeah.
Yes. Through Tyler.
Mm-hmm. Oh, yeah, of course. Of course, Tyler.
Yeah.
Yeah, go ahead.
So this question was based on the thing that you mentioned initially, which is if you have a long gap in the work, then your H-1B status is not maintained. Now, does this simply apply because you're not working or you're not using the H-1B, or is it just the law?
Nobody really can tell you if it is the law. I'll tell you what the issue really here is. An H-1B is a composite of both having the time of approval, temporal approval, I'm approved for the next 2 years, as well as pursuing the activity and getting paid for it. So there are two components. You've got the duration and you've got the activity. They both must coexist in order for you to have an H-1B valid. So if you stop working, you still have 2 years left on your H-1B, but you're not in status. If you stop pursuing the activity which is working in the described job, that is a cessation of your H-1B. Now, if you have a very good reason, and the duration is coextensive with that reason, I think you're okay. Wanting to do charitable work or non-profit work is not going to be sufficient as a reason, in my opinion.
I see. Okay. And a second question was, so you did mention that if I quit, which was probably my second option, and later on I could apply for another H-1B
next
through
6 years.
Say maybe the same employer.
Yep.
In the next 6 years, you mean?
Yeah. What happens is the current law is that if your H-1B was approved anytime in the last 6 years, you're not subject to the quota. You can take the remaining H-1 period, which is left on your original H-1, and come back anytime you like.
I see. So in my case, I know that I've completed my 6-year period on H-1B. Now I have an I-140, and probably could get 3-year
Okay.
extension
Hang on
indefinitely. That makes
hang on one second. Is your I-140 approved already in hand?
Yeah, it has been approved. Yeah, it was approved in March
Okay.
this year, March or April.
So let's say April, May, June, July, August, September, October, November. So it's over 180 days already, correct?
Yes.
So in that situation, you should be able to come back and work for any employer based upon that approved I-140 without having any problem with the quota, even if the old employer revokes the I-140.
Oh, I see.
That's the law since January 2017.
I see. Okay.
Okay.
And so, sure, this actually means something positive. I just want to confirm.
Yes.
Because
Absolutely.
then,
And
so
also,
then I don't even have to.
Yeah, Sunny, I want to add one more thing. Because you have an I-140 approval, that priority date is yours to keep forever and ever and ever. So when you start a new green card, let's say you start a new green card in the year 2020, it will still carry the priority date of 2016 or 2015 whenever you file this green card.
I see. Okay. So then, in this scenario, say I leave the country, I'm out for 6 or 8 months, I have my I-140. My only, the only thing that I'll have to do at the time is to either see if my current employer will hire me back, or if there is someone else that can hire me back using my I-140 that has already been approved.
Right, and you will have to start a new green card, but the green card will carry the old date.
I see. So when we say I'll have to start a new green card, it just means the whole process of labor approval
all over
and
again. Yes.
Okay, I see.
All right.
Okay, great. That answers my question. Thank you so much.
Good luck. Tell Tyler I said hi. Okay.
Will do.
All right, bye-bye.
Bye.
Okay. I think we are done with all the frequently asked questions. Now let's start with the... Oh, there is one more hand up. Give me 1 second. New Jersey, go ahead, please.
Hello, sir. Hope you're doing good.
I'm good.
You told about reusing the H-1B for 6 years. So if my current petition is itself a cap exempt from the original, still can I go ahead and use within that six year time frame?
So you have a quota exempt H1. Is that what you're saying?
No, I had a H1 in 2012 that was subjected to quota, but I didn't travel at all. I didn't come to US at all in that.
That's a little different question. See, when do you become quota exempt when an H1 is approved? That's the question that you should be asking. When do I become quota exempt? And current thinking of government is you become quota exempt once you get an H1 visa stamped if you're outside USA. Whether you come in or not, that is not relevant. Or if you're inside the USA, you get a change of status and your H-1B is not revoked in either case by October 1st of that year, you are now quota exempt. But if you did not get an H-1B visa stamp, or you did not get a change of status if you're in the United States, then government says you are still subject to the quota. I disagree, and we've actually been able to get several H-1Bs approved with these kind of cases without there being a quota issue. If I were you, I would certainly have the employer spend the money and try see if government will accept you as being quota exempt. Okay.
Sir, I actually came here in 2015 and now I'm on H-1B. I used the 2012 petition and the visa was stamped as well. The visa was also stamped, but I didn't travel. But again, I came here with my husband as a L2 dependent and I found a job. And then my employer sponsored for my H1 and I got a cap exempt approval and I'm on H1B status now.
Oh, good.
now if I'm going on a break now and say my original petition was in 2012, so if I'm going for a break next year, am I still eligible for a cap exempt in 2019?
Yes, minus all the H-1B you actually used. So between 2012 and let's say when you entered USA in 2016 or 2015, you didn't use the H-1B for 3 years, right?
Correct. I started using the H-1B only in 2017.
Yeah. This is called the remainder option. Look it up. The remainder option. So H-1B remainder option will allow you to use only the time that is remaining on your H-1B if you are trying to be quota exempt. And under the recapture rule, you can recapture all the time that you have not used. Okay. So it's a strange set of rules. Some of them are completely opposite to each other, but that's what I would argue, that okay, I can use the remainder and not be quota exempt, but I'm also outside the United States. I can recapture that time. I think that should work for you.
Okay, sir. Okay. Thank you.
Good luck. You know, it's weird how complicated immigration law is. It will make your head spin. I personally think anybody who has less than maybe 10 years of experience in immigration law doesn't quite understand how complicated it is. Extremely difficult to understand. There's so many moving parts. Okay, let's go on to our regular questions. Trupti Gawande says, I'm on H-1B from 2006, valid till 2018, visa stamped, moved to California from DC, new client location. They filed amendment, got an RFE, it got rejected. We refiled it with new client letter again, case is still pending. Can I travel? What are the risks? What documents should I carry? Shall I change it to premium processing? I think you should change it to premium processing, because if you started working for the client and you didn't move, although I think you maintained status all the way, because when you file for an amendment and you move to a new client, that's legal. If that gets denied, you become illegal if you continue working for the same employer after the denial. But if you changed an employer validly again with a proper amendment, that may not work. You know what? I could be wrong. I think you might be out of status, because when you filed a second amendment, your first amendment had been rejected. I'm trying to parse through all the facts of your case. So under the circumstances, because I don't know whether I can call you out of status or in status, I have to work it out. Because I have my doubt, you should discuss it with your lawyer, but I think premium processing is a good idea. And I won't make travel plans until this thing is settled. Okay, go ahead with your premium processing. *5 if you have a follow-up question on this. *5. Okay, there is one. And this one is from Texas. Texas, go ahead, please. Texas.
Hi, good afternoon, Rajiv. Thank you so very much for your service. My name is Tirupati Reddy.
Yes, sir.
This is regarding my I-140 is approved last year, September. I am an L-1A.
Okay.
Is it still possible for me to change the employer?
Your I-140 is approved.
L-1A.
L-1A. Did you file a 485?
Yeah, this October I filed.
This October, which means last month.
Yeah, last month I did my fingerprints. I am just waiting for other process.
Look, this question has nothing to do with what I just discussed. So normally I would not answer this question. So guys, please ask me only follow-up questions that are relevant to the discussion. We have time, we'll do new questions. I don't know if we will have time. Nevertheless, Mr. Reddy, since you have already asked the question, the answer is simple. International managers and executives are entitled to job portability under AC-21, but AC-21 kicks in after 180 days of the 485 pendency, not before that. So from October 180 days onwards, you could take a similar job anywhere, not before.
Thank you.
Welcome.
Thank you very much.
Good luck. Okay.
Thank you, sir.
You're welcome. Again, folks, let us stick to relevant questions until we come to new questions. I don't know if I'm going to have time today, but I will try my best. This is SHD, says, myself and my wife entered USA in 2005 with H-1B. Now we've got a green card. Oh, okay. Well, somewhere there was a last name that was incorrectly entered. And when they tried to get the social security number, they found out it was all resolved. Now they are planning to apply for a US citizenship. Will this cause a problem? Look, when you apply for naturalization, government does go over your entire history, but this does not appear to be a major issue. I don't think it's going to be a big problem. In fact, I think naturalization may be the ultimate cure to all these name discrepancies. So you might have some delays, but doesn't appear to me to be kind of issue where you need to stay awake at night worrying about it. I think it'll get resolved. Okay? Might be some delay, but it might cause more delay to try to get it corrected than to just go through the naturalization process. So if I were you, I would just file the naturalization application. That's my recommendation. *5 if you have a follow-up question. *5. Okay. New York, go ahead, New York.
Hi, Rajiv. Thank you so much for your answer.
Yes,
this is SHD. Rajiv, the quick question is, in the N400, that form, naturalization form, they're asking, did you ever use any other name since your birth? So what should I mention? Because we never used this name.
So,
this name was a last name incorrectly typed.
Right. What I would do is, I can't help you fill a form. Remember that, because if I help you fill a form, I have to sign it. But I can tell you this, if there were ever a situation in which I needed to present some information where the form itself is not quite covering it, I would attach an explanation saying that I want to note for the record that we never used a name like that, but that name will exist in our records because it was mistakenly inserted. So I would attach a letter. It's not a question of filling out the form. And I think you're right. If you've not deliberately used it, how can you answer that question? Yes. Okay.
So we no need to correct or anything, let it apply.
Yeah, I think,
so do they ask
I think the naturalization would be the ultimate cure for the correction.
So they will ask, do they need to correct any name? So that time I have to mention that this is not my name. It has to be removed from the records.
Yeah.
Is it correct?
They can't remove anything from the record, but when they give you a naturalization approval, that really is very strong evidence that all that has been looked at and it's not an issue.
Okay, but this is not in the last name record. This is in the prior or other name in the SSA records.
Yeah, that's okay.
The last name incorrectly typed.
You'll be fine.
That's good.
You'll be fine.
Okay, sure. Thank you, Rajiv. Thank you very much.
Good luck. Okay, let's go on to the next question. I like that handle. The handle is Be Kind. That's a good handle. She had two questions. Why did I think she's a she? I think she's a she. Okay, she or he. Be kind. My spouse and I, they had two questions and I combined them both. My spouse and I came to US in L1 and L2 in 2015, started working on L-2 EAD from June of last year. I had an H-1B petition stamped in 2012 but never traveled to US. Weren't you on the phone with me just a second ago? Okay. My employer applied for a cap exempt H-1B. I think she was on the phone with me just a minute ago. With a change of status to H-1 in May 2017, my spouse's employer applied for his H-1B petition under 2017 cap, got approved with consular notification. We're both traveling to India. His L1 is good till October 2018. I work from home. LCA has the home address. That's fine. And I work for a client who's in a different state. I'm supervised by my employer manager, and he's at the client side. Good. I have a clear employer-employee relationship. I work from a different state because my husband and daughter are here, and my daughter, who is 4-year-old, has been undergoing some therapies. I'm sorry. And my employer and client agreed for me to work from a different state. Good. LCA has home address. That's fine. I get paid according to my home address. That's fine. Okay. I'm worried if working from home should cause any issue with my stamping. No, ma'am. Working from home is a perfectly legal option. I don't see any problem with that. Daughter is on L2. If my husband alone exits for H-1B stamping, will she go out of status? Yeah, because if he doesn't have L1, she doesn't have L2. Can I apply for a change of status from L2 to H4? Absolutely. So what you do is apply for change of status right now before he exits. Once you apply for the change of status, she's good to stay. Okay. Then you said, if my husband gets his H-1B stamped, will the L1 visa be cancelled? Yes. Can he travel on L1 again? If he still has the job, he can always apply for an L1B visa again, even after the H-1B is denied. Next question you had was, while applying for H-1B, my employer asked me to post the LC notice in my home location. Well, I don't think that's the right thing to do. Department of Labor has indicated, not clearly, I'll give you that in these situations, they want us to post at the client location. So if I were the lawyer representing you, I would have posted one at home and one at the client side. But then again, this is not really your headache, it's the lawyer's headache. And the Department of Labor is far from clear. So I'm not worried about working from home. *5 if you have a follow-up question. *5. Okay. And this one is from New Jersey. New Jersey, go ahead, please.
Hello, sir. This is me again. Do I have to ask my employer to post the LC again in the client location? Because what my employer says
I don't think you can correct it like that. I think you should talk with your lawyers, see what they suggest.
Okay. So, but they said it's the right way to do, and they think that's fine.
I would just send an email, tell them to respond by email, keep a copy of that. I don't think, like I told you, I don't think the Department of Labor has ever enunciated this clearly. And I think you're going to be fine. But not really, it's not really my call to give you advice on that. It should be your employers and your lawyers' discussion. Okay.
Thank you, sir. So during the time of stamping, do I, would this be a concern?
No, this is not an issue because this is a Department of Labor requirement. It never comes up.
Okay.
Okay.
Thank you, sir.
You're welcome. Good luck.
Thank you.
Okay. Let's see. Do we have another question? Yes, we do. This one is from Chicago, Illinois. Go ahead, Illinois.
Hey, Rajiv. Yeah, so follow-up question to that. So on the client letter, let's say if you're working remotely, so should we ask them to mention specifically his work location is such and such, whatever the home location is?
I think that's always a good idea because it clarifies matters and it makes things a lot easier for anybody to handle. So having a specific work location stated in the end client letter is definitely a good idea.
Okay, yeah, because that's what I was planning to do, to get that in the client letter and then that's the LCA home address.
Yeah, you can say that she's working from home and according to our records or according to our information, this is her home address.
Okay.
All right.
Thank you.
You're welcome. Okay, let's go on to the next question. Reena Reddy says, my I-140 was approved on Jan 2017. I've got the approved copy. Now all of a sudden the status says new name update online. I have no idea what that means. What you can do is have your lawyers call the USCIS to ask them what this means. Is this just a glitch, unexplainable error, or does this really have any substantive meaning? So I don't really know what this means. I've never seen that before. *5 if you have a follow-up question. *5. Next question is Suresh7785. Company filed L2 blanket visa extension. I'll get the receipt notice by the end of November. Spouse's EAD will expire November 2017. Can I submit the form I-765? Yes, if you have filed for her L2. Okay, I think you mean L1B visa extension for yourself. So when the L1 application extension is, let me rephrase that. When the L1 petition extension application is pending, you can also file L2 and L2 EAD at the same time. Okay. Oh, I just noticed there's a question here. One second, let's see. There's a follow-up question from Tennessee.
Yeah,
Tennessee.
Rajiv,
Go ahead.
Yeah. Yes, Rajiv, this is a follow-up question for Rina Reddy, I-140 approval, new name updated.
Right.
I checked with my lawyer and my visa team, not with lawyer, but visa team. They said that initially our headquarters is at somewhere in Florida. Now they moved to New York. They said that because of that, it may happen. Is that any case like happens?
It can. Let me tell you how it can happen. And I'm not sure, only your lawyers can answer this question. Sometimes if you are working for a very large company and they have a lot of cases going, they can sometimes do a kind of like a, what do you call it? Like a batch update. So we can write a letter. We write a letter giving all the I-140 applications that are subject to that change and say we've got 130 cases pending with you. Here are their receipt numbers. Please attach the following information to them. Okay. So when they do a batch update, that can be done. But I'm not sure what happened. Your lawyers can best answer that question. But yeah, certainly that makes more sense.
Thanks.
Okay.
Yeah, thanks, Rajiv. Thanks very much.
Good luck.
Thank you.
Okay. Let's go on. So I covered the L1 situation. Can I change from L1B to H1B while I'm in the US? Yes. If you are maintaining status, I was on H1B visa in the year 2012. I used it for 1 year. Remember, your H1 and L1B are used together. So if you have spent 3 years on L1B, 1 year on H1B, you have still 2 years left on your H1B. Just make sure that you don't come to the end of your L1B period, then you won't be able to get your H1B extensions. *5 if you have a follow-up question. *5. Okay, I think we have a lot of follow-up questions today. Florida, go ahead, Florida.
Hey, Rajiv, this is Suresh. Thanks for the explanation. Yeah, actually, my wife's EAD, my employer did not file her EAD.
Okay.
They just did, like my L1 extension and her L2 extension. So they said like EAD, you have to do it by yourself, even though, like USCIS allows it. So I'm hoping to get the receipt notice by end of this month. And I'm not sure like on that receipt notice because she wouldn't be having her visa approval. So on that extension, I don't know if I can file her EAD.
Yeah, well, you can. As long as you have your application pending, you can apply for her L2 and EAD at the same time. There's a little typo in your message. That's what confused me. Your first line of message says my company filed my L2 blanket visa extension. You mean L1 extension. Okay. So yeah, the answer going back to your original question, Sureshji, is that can I file for an L2 extension and EAD while the L1 extension is pending? The answer is yes.
Okay, all right. And just in case, I've heard that there are a lot of rejection in L categories. Just in case, if it gets rejected, how many days I can stay here? Like, is it possible to stay here for a couple of weeks even after receiving the rejection?
I think a couple of weeks is a reasonable period of time. The law says you've got to leave immediately, but immediately is too unreasonable to expect for somebody who's lived here for, a few years. So if you left in a couple of weeks, I don't think that's the end of the world. But it's not legal, it is tolerated.
Okay. Perfect. Thank you, sir.
You're welcome. Good luck. Okay, let's go on to the next question, guys. I don't think I'm going to have any time left today. Today was a little slow for us. We had a lot of questions, but I'm going to try. I'm going to try to do all the questions I can. Time and energy permitting. Okay, mother's last name was spelled wrong, Vijay Chandra says. It doesn't match my birth certificate. I'm a US citizen. This is her name. When it somehow changed, she has a valid B2 visa. And it just looks like the name was truncated. Instead of Padmavati, it went to Padma, and the last name was misspelled. Yeah, I got that. Should we correct the name? Well, let's see. Remember, if you, and you should, I like to have the names and everything all corrected. But remember, a visa can only be corrected by reapplying for it. I'm not sure that they're going to be able to correct that visa any other way. If I were you, I would probably apply for it again, get everything corrected. Because she's coming in April, there's enough time. So my advice is please go ahead and correct it. Passport as well as the visa stamp. *5 if you have a follow-up question. Okay. NK Gokana approved I-140 with old employer, stayed with them 1 year or more after the approval. Current I-140 is under processing. My husband's 6 years H-1B will be expired on Jan 15th, 2018. Labor is going on. Can he move to H-4? Well, if, from what I remember, and I don't think I'm wrong in this, the regulations that allow you to reap the full benefit of the I-140 approval, even if revoked, state that the revocation should have occurred on or after January 17th of this year. So if your case was revoked before January 2017, that I-140 has very limited use for extending or getting H-4 EADs. Okay, so I don't see how that I-140 is going to help you. Yep, it can't be used for H-1B extensions from what I remember. Memory is not perfect, I could be wrong, but I'm pretty sure that if it was revoked, I-140 was revoked before January 17th, 2017, you get no benefit other than priority date, which is kind of questionable. That is still debatable. *5 if you have a follow-up question. Okay. *5, okay. Let's go on to the next one. Disha Khatri says, Chandike. I like that handle too. I'm currently working for employer A. Employer B is in the process of filing for H-1B transfer. I need to go to India for a week at the end of this month. You can travel. When a transfer is pending, you can travel. Right. Just make sure that your H-1B transfer is received by the USCIS before you travel. Can I come back to the H-1B transfer receipt notice and join the employer B? Yes, you can. Do I need to wait for the new paper copy to arrive before entering USA? You do not. Can I come back based upon the H-1B transfer approval notice without having the hard copy? Can I come back based on H-1B transfer approval notice I believe so. I don't think having the original notice in hand is a requirement of the law. So you can travel. As to what documentation you will need, I think that having an H-1B already approved with that approval notice, the old case, along with the visa stamping is good. If you've received the transfer already, having that approval will also be good. Okay. Do you have to have the original? I don't think so, but that's something you can double check with the CBP frequently asked questions, what documents you should be carrying. I don't think you will need the original. *5 if you have a follow-up question. Okay. Okay, this is wow. Guys, I'm very sorry. I don't think I'm going to have time to do new questions. There's still a lot of questions left, and we are already out of time. So I hate to do this to you. If something is really, really urgent, stay on the phone. I'll deal with it. But if it is not urgent, if it's just a general question, please post for the next time, okay? Thank you. All right, let's just go back to... but if it's urgent, just stay on the phone. I'll deal with it. Prakash 007. I-94s are not updated despite having gone outside and come back. What do I do now? So your H-1B amendment was approved without I-94. You see, they should have given you an I-94 co-extensive with your approval. So the first thing you can do is you can contact CBP. They have a set of offices which deal with correction of the I-94. They should all have the new approval date. So you need to contact the Customs and Border Protection and go there and tell them to give you an I-94 coextensive with the new H-1B approval. Double check with your lawyers. I don't see any reason why that shouldn't have taken place originally when you entered. And luckily, when you go to the CBP offices, chances are you'll deal with people who are better trained in law than people at the border. So when you go to the CBP website and just in their frequently asked questions, type correct error on I-94 or something like that, it'll give you a list of CBP offices that you can go to. Most of them have it on the airport itself, but there are other CBP offices as well. So go visit them and they should be able to correct this. *5 if you have a follow-up question on this. *5. Okay. Next question is, I was terminated from job on September 25th by employer A. They revoked my H-1B on October 5th. Employer B filed H-1B on November 8th, so after case was revoked. I have an H-1B visa stamp in my passport that's good till 2019. If the H-1B petition of the employer is approved without I-94, yeah, that's precisely the case of the guy before you, which is Prakash. So yeah, you should be able to travel outside USA once the H-1 is approved and come back with the old visa and the new approval, and they should give you the I-94 coextensive with the new approval. I don't think you should be required to have a new H-1B visa stamping. *5 if you have a follow-up question. *5. Okay. Doc Jads filed I-185 application in EB3 with the rest of the world. It's going very slow. What do I do to hurry it along? Well, see, the problem is you cannot really do much on 485 delays other than what you've already done. You tried the congressman. You can try opening an ombudsman's request You can type in a search engine USCIS Ombudsman. Try opening a case with them, but there really is not much you can do to expedite. You just have to wait. *5 if you have follow-up question. Okay. Now, since you guys have waited so patiently, oh, there is a question. Let's get that first. And this is from my neighborhood in Virginia, Washington, D.C. Go ahead, please.
Good afternoon, sir. Thank you so much for answering this question, sir.
Yes, sir.
My only question is, since my I-485 application and my I-140 application is pending since January, it's pending, it hasn't been approved. Can I change employers, or do I just wait with my head down?
No. If you change employers and they withdraw the I-140, you would have lost everything.
Okay.
Don't change. Okay.
All right.
If there is,
thank you so much. Thank you so much for your time.
One quick suggestion. Have you tried
yes, sir.
converting your I-140 to premium?
No, I haven't.
Why don't you try doing that? See, if they are not able to premium it, they'll return your fees anyway.
Okay.
Okay. Premium the case. Let's see if that works.
Okay. Thank you so much.
You're welcome. Good luck.
Thank you.
Okay. Anybody has any question? Let's do new questions. *5, please. Anybody has any question? Press *5. 1, 2. Oh, that's not too bad. 3. That's not too bad either. Okay. Yeah, we can do this. 3 questions is no problem. Okay, let's begin with Arizona. You logged in the first. Arizona, go ahead. What is your question?
Hi, my name is Antula, and I have a quick question regarding J1 visa. So I moved here in July on J1 visa, and when I moved here, I was in the process of getting my British nationality back in the UK. I hold an Indian passport. Now, I have been approved with my nationality. So I have to go back on December 10th to take the oath. And as soon as I take the oath, I'll get a British passport. My question is, can I transfer my existing visa from my Indian passport to British passport?
You have to apply for a new visa. There's no, as far as I know, there is no provision for transferring the visa.
Okay. Can I be exempted from the interview process this time?
That depends upon the local consular rules. When you talk about exemption, are you talking about exemption in the in the United Kingdom? Well,
like a waiver? In the United Kingdom, like a waiver.
That depends upon the local consular policies. By the way, I can also recommend this to you. They are actually pretty good about answering emails.
Okay.
So if you go to their website, they should have an email address for their non-immigrant visa section. Typically, it will go something like DOS UK NIV.dos.gov, something like that. So go to their website and see if you can contact them via email and ask them these questions that you have. One thing I want to point out to you, do you have a home residency requirement on your J1?
What does that mean?
Are you required to go back for 2 years to your home country?
Yes, I do. But my partner, my husband, like my would-be husband, we're getting married in a couple of months, is in the process of green card. So as soon as he is sorted, or the wedding takes place, I'm just going to move on to
it doesn't work like that. It doesn't work like that.
It doesn't?
Oh, no. I had a feeling you don't know the entire...
Oh, my God.
It's very complicated. Listen.
I really...
Yeah, you cannot...
Oh, okay.
There are 2 things I want to point out to you. And please have them in the back of your mind. If you have a home residency requirement, also called 212E requirement, it doesn't matter even if you get married to a U.S. citizen, you still have to go back for 2 years.
Okay.
The only exception, well, one of the exceptions is that it will result in extreme and exceptional hardship to your spouse if you were asked to go back. That's a difficult case to win. Okay. So that's number one thing to remember. Number two thing to remember is normally the way the regulations read is this. So when you got your J1, you were an Indian citizen living in India, correct?
No, I was an Indian citizen living in the UK as a permanent resident, just like green card
then
here.
You'll have to go back to UK for 2 years to fulfill the home residency requirement. Now, the home residency requirement can be waived through a waiver process. So you have to look into the waiver. There are only 4 ways to get a waiver. See which one applies for you. Get the waiver started. If you get a waiver, then getting onto your spouse's green card is no issue. But the timeline is important. First thing you need to do is get your visa stamp on your new passport, which is the UK passport. Come into the USA, and whenever you get married, that's fine. But start your waiver process as quickly as you can. Waivers tend to take a long time.
Okay. Thank you. Okay. And last question before I let you go. So if I get my British passport and I travel on my Indian passport, would that be a problem?
I think that's illegal.
Because I still have
I think that's illegal.
That's illegal.
Yeah, because I think India doesn't allow dual citizenship right now.
No, it doesn't.
So you'll be traveling on an invalid passport, which is probably a crime.
Okay.
Yeah. Okay.
I know, so much to do, but thank you so much for helping out. You've been great, and you gave me some.
Congratulations and good luck. I'm sorry to be the bearer of bad tidings, but I need to tell you how things are, okay? So you can plan for them.
No, you have to. That's amazing that you actually gave me a heads up about that as well. Great. Thank you so much about that.
My pleasure. Good luck, ma'am.
Thank you. You have a good day. Thank you. You have a good day. Bye.
All right. So we've got 2 more questions. Let's go to Illinois. Illinois, go ahead. Your question, please.
Hey, Rajiv. Yeah, thanks for staying back and taking our questions. So I have this quick question, right? Initially in 2008, my 140 was approved under EB3, and this year, I was able to port it under EB2, and now my priority date is current because it just moved to November 1st, 2008 for EB2. But I also qualify for cross-chargeability since my wife, she's an Indian national, but their country of birth is Jamaica.
Great.
So what do you recommend? Should I use cross-chargeability
or use cross-chargeability as well as priority date from the old case, both of them, so that even if the dates slip back, you are well protected.
Okay, so I guess in the application we need to mention we qualify for both.
Absolutely. No question about it. This is an easy one. Okay.
Okay. All right. Thanks.
Good luck. And the last question for the day is from Missouri. Missouri, go ahead, please.
Hi, Rajiv. This is Ravi. First of all, thanks a lot for, doing this community service. My question is pretty simple. I currently work for company A, and I have a valid H1 till April 2019.
Okay.
And I have done H1 transfer.
Okay.
So next week I'm joining company B. And my H1B is already approved from 1st of this month to 31st October 2020.
Okay.
But in case of my spouse, right, her H4, the validity is from 16th April 2019 to 31st October 2020.
Okay.
So basically, this new H4 kicks in right after her current H4 expires.
Okay.
So is this a normal? Because this is the first time I have received H4 like with different dates.
Let me try to understand what your concern is. Your concern is that my H1 approval dates and her H4 approval dates don't match with each other. Hers start and terminate at a different time. Is that what your concern is?
Her termination date is same, right, but her start date, right, is 2019.
Right. Now this is very normal, and this is the way it should be. Okay. Why? Because remember, every time you change H1 employers, she's not required to change her H4. Okay. Her H4 is valid whether or not you change 20 employers. Her H4 needs to be renewed only when it expires. So therefore, her H4 is not tied to your employers. Her H4 is tied to its duration.
Okay, got it. Just a little more clarification. So I know my company A, right, always withdraws H1 once an employer resigns, but they cannot withdraw H4, right? So H4 has nothing to do with the company in that
They
case.
cannot touch the H4. No.
Okay.
All right.
Thanks a lot, Rajiv.
Good luck. All right, guys. This one lasted a little longer, but it's always a pleasure to talk with all. Oh, hang on. Yeah, no, I'm done with the calls. Okay. So we'll see you again in 2 weeks, and thank you for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.